Good afternoon and welcome to the David Astburys Renters' Rights Act webinar. Thank you very much to everyone for joining us today. We've had well over 500 landlords signing up for today's webinar, which is absolutely fantastic. We've got a huge amount to get through, so I'm going to dive straight into it. Firstly, I'll introduce the panel of speakers today. So myself, my name is Adam Ray. I am Client Services Director here at David Astburys. We're also joined by one of my colleagues, Harry Foster, who's the Lettings Director over in Hampstead, was also my co-speaker at the seminar that we held last year. And we're also very lucky to have Susie Crolla join us. She is the Managing Director of the Guild of Letting and Management. And Susie is one of the most trusted voices on the Renters' Rights Act in the industry, especially from a legal perspective. So look, what you're here for today, what you're going to be leaving with. Susie is going to go over what's changing, the laws and what the implications of these new legislations are, the immediate deadlines that you need to be fully across. Then Harry and myself will be going into the various strategies you can employ to ensure that you're fully protected and prepared to navigate what is going to be coming with the new landscape. Now, you've obviously heard a lot about the Renters' Rights Act from various sources, a lot of different narratives being built in the media, different organisations, different agencies having different approaches as well. We're here to cut through that noise, and we want to answer the real questions that landlords like yourselves are posing. And as you can see from the research that we've done, from the questions that have been put forward for today's webinar, there are wide-reaching, widespread topics that you're concerned about, and it's not just one particular area. So each individual has multiple different concerns. That does kind of boil down into 6 or 7 different areas of the Act, which a lot of you want to be addressed, and that's what we're here to do today. We're tailoring it to the specifics of what you want to know, and we're here to provide those practical solutions and the advice that you need to go forward into this new world of lettings. So where are we now? 1st of May, this is phase 1 that we're entering into. As we know, the Renters' Rights Act is split into multiple phases that will be coming throughout the course of the next few months, over the next couple of years. Today's session, we are tight for time. We are going to be focusing on phase 1 and the immediate deadlines that we need to be aware of. With that said, I'm going to pass over to Susie, who's going to be taking on the initial stage of this, talking about the legal clarity in practice. So Susie, over to you.
Thank you, Adam. Well, good afternoon, everyone. One of the things that makes me extremely happy is the fact that there are so many people online registered for what I deem to be this kind of very last preparation and move towards the beginning of phase 1 of the Renters' Rights Act. As Adam said, today we are purely focusing on phase 1. So we're moving towards effectively a week tomorrow, which seemed like it was a long time away, but it's crept up on us really, really quickly. So I'm going to focus on the key elements of what you need to be aware of as landlords. And remember, one of the things that you have available to you is on this platform, you have a great level of expertise. The team at David Astburys can help you navigate what's going to happen up to and including the 1st of May, and then obviously beyond. So I want to focus on the implementation, and we're going to talk about paperwork. Now, one of the things that's really important, we waited for information from the government, and we had hoped that it would come in early March, but it was kind of the tail end of March. So there's been a flurry of activity around these new legal duties. And obviously, the umbrella of the Renters' Rights Act is effectively a new legal duty, but I want to drill down into the detail of the fact that we will no longer, from the 1st of May, have what is known as an assured or an assured short hold tenancy. So one of the things that's really important, no fixed term. So how do we navigate those existing tenancies? And there are millions of them. and the new tenancies. And for the existing tenancies, we need to think about the information sheet. Now, this is something that has been issued by the government. It's a government document. It's in PDF format. And this information sheet is something that will only be issued once. It's not going to be issued throughout the rest of 2026 and into 2027 because the landlords have been given a very clear deadline. So the information sheet advises existing tenants that their tenancy is no longer an assured short hold tenancy or an assured tenancy. Effectively, we're converting all existing tenancies by issuing this document starting the 1st of May, and the cut-off, really important, is the 31st of May. And I want you to think about something very carefully. If you're navigating this on your own, you really need to meet those time frames. Okay, because the 31st of May is actually a Sunday. So you need to check some things in relation to your existing contracts and so on. Now, I've made reference to guarantors. I just want to make sure that you're aware that you can issue the information sheet to the guarantor, but it's not a mandatory requirement. Okay, it's a belts and braces, good practice. In terms of the tenants, the government has given you four methods to issue the information sheet, but this is extremely important. Check your tenancy agreement. What does it say about service? And then also, if you have 5 named tenants on the tenancy agreement, that means 5 copies issued to each individual. Okay, so that's really very, very important. And the information sheet is really easy, very straightforward to follow. It's a 4-page document and it has to be issued as a PDF, okay, not in Word, not as a link. Okay, so that is really, really important. So that's the first part. That's our existing tenancies. So what about these new tenancies? The new tenancies, we need to navigate slightly differently. And what the government have introduced is something that has been brought over from Welsh law, Welsh housing law. And this is the written statement of terms and information. And basically what I look at this as is a summary of the terms of the contract. Okay. And ours, we supply this kind of paperwork and it's 4 pages long and it gives the tenant an overview of what is in the contract. Now, this can be dealt with in one of 2 ways. The information, the written terms can be issued before the tenant signs the assured periodic, or it can be combined within the assured periodic. But really, really important, it has to be served. Okay, so you have to prove you served the written statement. That's really, really important. And that you can prove that the tenant has received it and signed the terms. And basically what the government are saying is by serving this kind of abridged summary of terms, the tenant will then be aware of what they're signing up to. Okay, so very, very important. And remember, your assured periodic tenancy is going to be very different to the assured short hold and the assured tenancies that we've been using, just so we're clear, for the last 30 years. Okay, so make sure, you know, like I said, you've got David Astburys on side. They can assist you with anything in relation to your paperwork. So, removal of Section 21, a massive headline since 2019. And you can see I'm smiling, but that's nerves. Why? Because this has been incorrectly described as an eviction notice. Okay, I don't know if anybody read the Times last week, but the Secretary of State was shocked that landlords were serving Section 21s, and he said all these eviction notices, they're not eviction notices. So I just want to clarify, one of the reasons for removing the Section 21 is because obviously if we have no fixed term tenancy, we don't need this document, okay? But also it has been misused. I mean, I'll grant that. That's very important. So you can carry on serving a Section 21 up to and including the 30th of April, but I would be really, really careful. I would seek legal advice. I would not panic, and I would make sure that it's a belts and braces service of notice. Okay. And you may not rely on that notice, or you may. But if you do decide and you have served notice, you have a cut-off within which to start court proceedings. And that is the 31st of July. And that means that the court claim, the papers, need to be in with the court by that day, and that's cutting things really fine. So again, you need to make sure, firstly, do you actually need to serve a Section 21? You're up against some very strict timeframes. Remember, next week, 30th of April is your cutoff. And then if you decide that you're going to have to go to court, it's really important that you seek legal advice, because again, you've got another deadline that you need to meet. So in removing Section 21, what are we left with? And I know that Adam has prepared a slide for a bit later on. We're left with a Section 8 notice. And the Section 8 and these notices have been given new names, and that's since 2015. This is not new. It will be known as a Form 3A, but we refer to it because for ease as a Section 8. The Section 8 is an evidence-based notice. Can I stress it's not an eviction notice? And you will require reasons. And effectively, if we clump them all together, there are 18 grounds, reasons that you can rely on as a landlord. And the government have pretty much covered everything off. But there's some new ones, and I've added this at the bottom of the slide, is that we have ground 1, which is not new, where the landlord could potentially want to take the property back and move in, or a family member. But the new one is ground 1A for sale. But these two grounds are the only grounds that carry some quite significant, not insurmountable, but some significant restrictions. Okay, so the premise behind this, firstly, if you decide to serve a Section 8 in the future, moving from the 1st of May onwards, you need a reason. So you need to keep your records really clear and up to date and have all the relevant information. Secondly, if the tenant doesn't vacate, and there are notice periods for all the grounds, ranging from immediate, 2 weeks, 2 months, 4 months. At the end of that period, then you start court proceedings as you would normally. Okay, so that's really important. And then thirdly, timing. Okay, you need to think really carefully, especially when you're using grounds 1 and 1A. Okay, to have a discussion. If you've got a managing agent, they're going to guide you, they're going to support you, but think really carefully, do I actually need to serve a Section 8 notice? Because that's when those restrictions kick in. Okay, so that's really important. Navigating rent increases. Now, this is another key notice. So we're not going to be using Section 21. So we have 2 key notices. These aren't the only ones, but for us in the sector is the Section 13, and this will be known as a Form 4A. It's not a new notice. People keep telling me this is new. It's been around since 2003 in its current format, and way before then, probably since 1977. But elements are going to change. One of the key things here is that we have been used in the industry, agents, landlords, and so on, to increasing rent, relying on a clause in the contract. That clause will no longer be relevant. So no references to RPI, no references to CPI, no references to percentages. All the contracts that have been newly drafted will make reference to this new mechanism. And the new mechanism, because we're moving to periodic tenancies, is the Section 13. 2 months notice in line with an anniversary date or rent period. The rent has to be increased in line with market rent. And this is really important. Now, my skill set is not valuing properties, is not dealing with market rents. That's in the hands of an organisation like David Astbury and the team, and that's their skill set, and this is what they understand. So they will be pulling together a huge amount of information known as comparables. They know where to look for it, they know the premise behind it, they know if the property is particularly quirky or different, they know how to get the comparables. And those comparables are going to be so important because what they're doing is they're demonstrating market rent to the tenant. And in the event that the tenant does challenge the increase, which is their legal right, I'm not saying that every single tenant in England on the 1st of May is going to challenge a rent increase. I'm not feeling that at all. But in the event that they do, you have that comprehensive amount of information. Okay, so that's really, really important. The tenant, as I said, has the right to challenge the increase within that 2-month window. Okay, so if the rent is going to increase on the 1st of November, they will have that 2-month window prior to challenge the rent increase. And they have to do it, and they have to pay. It's £47 for the tenant to do that. Now, one of the concerns, and this is why I would prefer to avoid going to the first tier tribunal, is that if the first tier tribunal agree with you, they agree with your rent increase, which most definitely is a possibility, then that rent increase, if it's taken 6 months to come to that decision, that rent increase will not be backdated. Okay, so I would prefer to avoid that. I would prefer to work with my agent. I would prefer for my agent to negotiate for me because, quite frankly, I don't want to miss out on my rent increase for a 6-month window, which could be £600. Okay, so this is very, very important. So use the superpower team that is around you. More points about rent. This has been discussed a lot, and I know that Adam, prior to us starting the session today, talked about some of the questions that possibly could be asked in this live session. So rent in advance is a big one. There's a lot of information around that and a lot of inconsistency in terms of comments. So we'll probably address that a bit later on. I'm sure that will come up in the Q&A. Rental bidding will be unlawful. And what does that mean? That means when a landlord or a letting agent encourage tenants to pitch against one another. Okay, so that will become unlawful. And then also something that is very, very important because, you know, the evidence is out there in the public domain is that landlords can only accept offers for advertised rent. So if the offer comes in £200 above the advertised rent, it would be illegal for the landlord to accept that offer. Pets makes me smile because huge amount of time has been spent on this in the House of Lords, House of Commons. More time spent on this than talking about children, which should tell us all something, but there we are. So before we say, I'm not going to accept pets, the tenant has to go through a process. Now, I know, and every single landlord in England knows, and probably their agents, if the landlord is going to accept pets, but the tenant must make the request in writing. Okay, and as guild members, David Astbury have access to a lot of our documents, and one of my favourite documents, which sounds very odd, is the pet profile. So the tenant would have to fill in chapter and verse about this pet. Okay, once that's done, the landlord has a time frame. From the date of the request being made in writing, the landlord has to respond and either give consent or not. Okay, and that's within a 28-day window. And then a further 7 days to explain if there is a reason for refusal. Okay, so that is actually quite important because that's something that we would put in writing. Okay, and potentially, and you know, all of this is up for discussion. The tenant could decide, I really don't believe that that is a valid enough reason, and challenge that reason. Okay, so that's important to bear in mind. Now, as I very briefly mentioned, children. This element on this slide has actually been around for a while. It's never really been embedded heavily within the Equality Act, so it doesn't sit within the Equality Act, but it is something that, you know, if anybody were interested, you could find a huge amount of case law. And this is where landlords and also letting agents have refused tenants without looking at the facts. What they've said is the tenant has said, I'm in receipt of benefits, and it's an out and out no. There literally is no discussion, you know, no opportunity to view the property, no opportunity to go into the detail of whether the tenant does, you know, pass affordability and referencing and so on. So this is very important. The way that we avoid this is to treat everyone the same, okay? And that is really important. So on a case-by-case basis, we look at what the circumstances are of the tenant, if they want to view, if they feel that this is something that is really important to them, then they are allowed to view the property. So it's excluding a demographic. That's what discrimination means. It means that because somebody's in receipt of disability benefit, you will never show them the property. Because somebody has a child under the age of 8, they will never get to see that property. So that is really important, but the rental discrimination would have to be proven. Okay, so no statements on any property adverts, any property details that make statements about excluding certain demographics. Okay, but the government have introduced something else as well. It's known as a proportionate means of achieving a legitimate aim. Now, what does that mean? The example I've given you on screen is really important, and you will have access to that. I can think of hundreds of examples where you would refuse somebody based on a legitimate reason. And the legitimate reason I've given you here is safeguarding of children. But it could be related to health and safety. It could be related to the fact that the landlord can't make reasonable adjustments to the property to accommodate a family where the children are under the age of 5. Okay, so it could be related to the size of the property, overcrowding. And what this means is that in refusing, the landlord is not discriminating, but also is not breaking or in breach of another element of housing law. Okay, so that is really important, and there's really good guidance online. Now, that brings me to the last 2 slides, and normally I start with these. But I think, you know, Adam and his team have made a very sensible decision, because I think you really do need to understand that whilst there has been enforcement around within housing for many, many, many years, 50, 60, 70 years, the level enforcement in relation to landlords and also letting agents, because everything I'm talking to you about applies to both letting agents and landlords, is going to be a lot tougher. Okay, the local authorities in England, and that is the whole of England, doesn't matter where you are in England, the local authorities have been given new enforcement powers. And I'm just going to split them into 2. The first is on screen, and that is the local authority has the right to write to any landlord in England and any letting agent and put a request forward for information. Now, this sits under the Renters' Rights Act, and it's under section 114, and they need to tell you why they need the information, and it's obviously going to be that they suspect there is a breach. Okay, and it's going to be a breach of housing law, health and safety in relation to housing, unlawful eviction, and so on and so on. They also will tell the landlord and or the letting agent the type of information they need. So if you think about the property file ranging from pre-tenancy, during tenancy, property inspections, paperwork, maintenance records, everything, all of that, okay? But not anything that's GDPR sensitive. Okay, so no details about the tenant, no details about tenant's right to rent, no details about financial sanctions checks and so on. Okay, so they will give the landlord and the agent a time frame, minimum 7 days to comply, which is not a lot, maximum 28 days. If that information is not forthcoming for whatever reason, the local authority will obtain a court order, okay, and they will obtain it really quickly. Okay, so that's the first thing. The second thing is linked to this, and it looks exactly the same, but it's known as an inspection without warning. Okay, so what the local authority can do, and they normally work in pairs, and these are housing officers, environmental health officers, enforcement officers, is they can attend the business premises of an agent or a landlord and then appear without a warrant. And they can ask for all this information whilst they're on site. And this is really important. I've not experienced this yet. And bear in mind, this changed in, or was introduced in December 2025. But I have seen the letters. I've seen a lot of letters coming through, and we have discussions with clients who are landlords or agents who have received the letters. I've not come across any visits yet, but that's not to say never. Why would the local authority appear without a warning? Basically, they don't want to tip anybody off because the level of breach is so serious that it warrants, no pun intended, but it warrants an inspection without giving the agent or the landlord notice. Okay, so that is really, really key. Now, that leads us to the penalties. These penalties, very much dependent on the offences. But there are 3 things here that I want you to think about. The first thing I want you to think about is, do you want to be in this position? We are a belts and braces organisation. We work with our clients to minimise risk. And you can't ever eliminate risk. It's just not possible. But our clients do the same for their clients. So David Astburys will be doing the same for you. They will be the gatekeepers. They will be the safety net. They will make sure that everything is as it's meant to be to avoid this. The penalties from the 1st of May start with first offences of up to 7,000. So I'm going to give you an example of something we talked about at the beginning, and that is the information sheet. Failing to serve the information sheet on existing tenants, or serving the information sheet after the 31st of May could result in a penalty, financial, of up to 7,000. Now, you might think, goodness, that's over the top, but we don't know. We don't know whether the local authority will decide to fine £500 or 7,000, but that effectively is a possibility. The subsequent offences, and this is something a lot bigger and a lot more significant, is the penalty for an offence of up to 40,000. Okay, so the example that I would give you is that the Section 8 notice under the ground for sale has been misused against a tenant. Okay, the landlord served the notice, the tenant vacated at the end of the 4-month period, no problems there, and then the landlord relet. Okay, that is a definite £40,000 fine. Okay, so you need guidance, you need support. this is a time to really rethink, do I want to face this? And the answer to that question is absolutely not. But then there's another layer, and I describe this as a type of cake that nobody would ever want to eat. We have this layer of rent repayment orders. Rent repayment orders have been around under the Housing and Planning Act of 2016 since 2018. So they're not new, but you really don't see them very often. I deal with them on both sides, for tenants and for landlords, and forgive me if that upsets people, but you know, it's two sides of the same coin. The tenant has the right, if there's an issue under the Renters' Rights Act, in relation to disrepair, under legislation relating to licensing, to apply to the first tier tribunal for a rent repayment order. Now, up to and including 30th of April, the rent repayment orders are capped at 12 months rent. Okay, so if the tenant's been living at the property for 2 years, the tenant could only claim up to 12 months as a rent repayment order. From the 1st of May, that jumps up another 12 months. So the maximum a tenant could claim back is 2 years worth of rent. And I would tell you, it's not worth it. It is not, it's worth it for the tenant. And I tell you, it's an easy win. But you really need to factor this into your business. You do not want to go to the first tier tribunal up against a rent repayment order. Okay, so as I said, I've seen them on both sides. Generally for the tenant, if they have the evidence, it's a really easy win. Okay, so my premise is not when you receive one of these. You never want to receive one of these. You really want to make sure that your business, and I'm talking about your portfolio, the way that you run your business, is super well protected. Okay, and that is generally why a lot of landlords use agents, because this is most definitely not for the faint-hearted. So that's my part for you. I hope that's beneficial.
Perfect. Thank you very much, Susie. I'll just crack on now with, of course, we've had an idea of some of the problems that we could have.
Mm, mm.
And sorry, of really what can we do? So as Adam mentioned, I'm the lettings director of our Hampstead office. And what I'm going to talk about in this strategy is really how we're going to approach this. So it's really breaking it down. That's a big question, how we're going to approach this. So I'm going to try and break this down into 4 points. So the first point we have is the product. It's the property. That's exactly how tenants are going to view this. So we need to look at the property, firstly assess, is this, you know, a good place? Is this something someone would rent? Are there any outstanding problems, issues? Needs a little bit of investment at the start. We need this to be an attractive prospect to attract those good, reliable tenants. And we also want to know in our minds, with this type of property, what type of tenant will it suit? Who will be most happy here? And it's very important to know that from the outset, to just have an idea of this is what we think will work in terms of tenants and who will be happy here. Now, factoring that in, we've got the product, great, price. So with the pricing, it's very much pricing it right, pricing it fairly. And that word fairly will come back a lot, because that's a lot of what this bill is about, is what's fair. So one of the questions I had, we've actually put it in there, was mostly about overbidding and how would that work. So there's 2 schools of thought on how to approach this in terms of the pricing. The first being is, okay, if we can't bid for a property over asking price, let's inflate the asking prices so that people will come in below. There's one. And then another school of thought is to price the property at the true value, the fair price, and then get it rented at that price. Because you can't take above, well, that's fine, it's not worth more. And if you have something below, well, if we have an excellent tenant who we think is a fantastic profile, reliable, but also good people, which I think is important more than ever, then we consider it there. But there's, like I said, there's those 2 options, and how we position it is dependent on, you know, those people we're trying to find, those good, decent, reliable tenants, and that definitely do exist. I'm sure we've had, you know, for every story that there's a bad story about a tenant, there's 5 more really, really good stories about tenants being very good. So that's where the pricing is quite important. And then positioning. Now, positioning is talking a little bit more about that pricing. So we've spoken about two strategies we could operate there, but it's important to note that most people will use Rightmove and Zoopla for their searches. So Rightmove and Zoopla, their pricing brackets are broken down in certain ways. So for prices up until 3,000, the pricing brackets in increments of 250 per month. Beyond 3,000, it's 500. And for those lucky few with property of around 5,000 or more value, it goes up to 1,000. So when we have a property, for example, I have a 2-bedroom flat, it's worth probably 3,400 in true value, but we really want to get reliable people. You know, maybe the landlord's looking to move back in 2 years. They really want their home to still be their home when they come back to it. So how we might look at a property there is, okay, the property value is 3,400, but if we price the property at 3,500, we're effectively doubling our inbound market exposure. The reason why is we're hitting a bracket of 3,500, so that everyone from 3,000 to 4,000 will see your property. The main goal of this really is exposure, because what we want to do is, if we're saying we really want the best tenant, we really want someone who's great on paper, yes, but reliable and has a fantastic landlord reference that we can rely on. So what we need to do is we need to really maximize that filter from which we can then find that one offer that we're really happy with, that's a fair price and someone we can go ahead with. So that's talking about the price, positioning, and the different schools of thought of what we'd look at. What Susie talks about, where agents and of course David Astburys, what we do here is that qualification. Now we can talk about what I'm sure all agents talk about. Do they earn enough money? Great, you know, that's kind of a lot of what they will go into. But we need to know far more than that. We need to know, you know, credit score wise, there's not going to be any problems. No county court judgments against you, of course. But a lot of what we do is we go further into personality and landlord side. So we try and get their landlord details, especially at the point of an offer, so we can go ahead and call that landlord. A lot of the time, landlords might do a bit of a tick box exercise. Have they paid rent on time? Yes. That doesn't fill me with confidence. That's the bare minimum. What we want to know is, you know, if there's a problem with the property, how are they with reporting it? How are they with allowing inspections and access to the property? Or a lot of the times I get, you know, there was a mold problem and my tenant didn't let me know, or maybe I could have caught it earlier. And what began as a small problem and could have been solved as a small problem, but then became a really big problem and a really big cost. And we can find that out by speaking to the current landlords of these tenants that we speak to, because they know best. They know as well as anyone that, you know, what were they like? How are they like to deal with? Not just have they paid the rent on time. David Astburys, that's hugely important for us. We need to get it right at the start. We need to put the right people in these properties. Otherwise, for the reasons mentioned before, if we want to get them out, there's no longer that mechanism to change the situation. And the control is very much in the tenant side, which could be a good thing, it could be a bad thing. It just depends on how that control is used. So with that focus on qualification, and a good stat we want to share with you today is that a lot of people we have with the offer, once the offer is accepted, the referencing side is almost a formality, because we already know that these people, they have the money, they have the earnings, we know why they're moving, what their long-term plans are, but most importantly, that they're reliable people, that we will be happy with the property and you will be happy as tenants in there. So 96% of the people we have who have their offers accepted with us will go ahead and be our tenants in the property. And it's just a really important part. That's looking at what do we do before we have the tenant. What we want to do now is, okay, we've got the tenant, how do we keep them? The question I get asked the most, and I think it's quite a natural concern to have, is that idea of a tenant can serve notice, 2 months notice at any time within the tenancy. So that means in theory, a tenant could move in, I've spent all this money maybe putting the property, getting it ready, and the tenant then leaves 2 months later. Now, of course, the pre-qualification will prevent that. If someone's looking for a short-term let, maybe we find that out. We will generally find that out early. So we'll reduce that risk there. But a lot of the reasons we found tenants would leave is maintenance. It's a maintenance situation. If there's a problem with the property that is ongoing or not sorted out quick enough to their liking, that could cause them to leave. And it's really important, that retention and how we retain those tenants. And a lot of them, they need clear expectations. When is this going to be resolved? We've had landlords before call me, Harry, it's Christmas Eve and my tenant's boiler's broken. They're expecting me to fix it. You know, I'm with family. That's very hard to do, because and we've had this before, private managed landlords, they've got a life, they've probably got a job, they've probably got a family, they've got other things to focus on. So when a tenant calls them and says, sometimes the silliest thing, my light bulb's broken, what do I do? you might get back to them tomorrow, the day after. But now it will be a situation where tenants, if they're not happy with that side of things, they will be able to serve notice. And a really interesting stat that we looked at, when we looked at our tenancies and the average tenancy length that we were looking at, our managed tenancies were 8.5 months longer, almost 2 years, 22 months, whereas the let-only rent collect clients, generally the average tenancy was around 13 months. And for the reasons I just mentioned, it's maybe not, it's really that time and that consistency. And to be honest, tenants can be a little demanding when they need things fixed, but if it's a big problem, I think I can understand that if it affects their quality of living. So what we offer with our property management team is that 24/7 maintenance support and response. We're able to give them advice, but also we have a triage system. We really work quickly to find out the problem, but most importantly, find out the solution. People want solutions to their problems, as we all do. That's why we're here today. And that's how we believe we can maintain these tenants. And tenancies, we do expect to go on for longer periods. And there's huge benefits to that. There's huge benefits to staying on longer. A lot of the hidden costs that landlords would forget is when a tenant leaves, okay, you've got to do a checkout. Then you might have to do a professional clean again. And you also might have to sort out a few issues that have popped up, some teething problems or some conditions that the new tenant has requested as part of their offer. Now, those costs can really add up. Now, imagine if instead of doing and dealing with those costs and the headache of that every year, you're looking at it every 2 years. And that's really where the value will be in finding a really good tenant from the start who's reliable, you get on, who look after the property, reduces the number of maintenance issues, but then remains in the property and there's not that continual turnover. And that's where you'll see a real value to your investment. Now, on that continuation sort of situation where we have tenancies continued beyond 12 months, and Susie obviously gone into the process of Section 13 and tribunals. Now, Good Lord, our partner over in the referencing side of things, they gave us a really interesting stat. You'll see there on the left-hand side that 22% of tenants will challenge the tribunal, regardless of whether they think it's fair or not. And the reason why we know that to most likely to be true and why tenants would say that is because the tribunal will cost them nothing but time. So they can dispute it 6 months later, even if we're right, and we've proven we're right, it won't be backdated. So a lot of tenants we do expect will do that. It's not as many, I'm sure some of you expected. It's a little less than 1 in 5. So a lot of the work we do is, as Susie said, is warranting that increase and explaining why it is the market rate, why it's fair. But also, again, if we have a good communication, a good relationship with those tenants, they'll feel more inclined to pay more. They'll see, okay, well, Harry's telling me the market rate is X. And also that time they helped me out with the boiler, the condition's been good, the property's been looked after. Also the cost of moving somewhere else, it's quite a bit for a tenant, it's stressful for them. They will be less inclined to dispute, more inclined to stay. And that's really what we're trying to do here is have that tenure. And that's, again, where I feel you'll see that value and return on your investment. So I hope that explains a little bit more on the continuation of the tenant side. I'll be handing back to Adam now to just talk again about those additional protections and how else we can help and what else you should be aware of.
Thank you, Harry. Yes. So look, Harry's covered how we attract the right tenants at entry, and we get those tenants in there at the right price to protect that element of it. Then, of course, we need to come on to how do we protect that income throughout the tenancy. So one, of course, is keeping your tenants happy. But look, as we know, anything can happen in life, and tenants, the best of tenants, can fall into positions where they might find paying the rent a challenge. And one of the big conversations that we've been having, and a lot of the questions that have come in prior and are coming in as we speak, are surrounding Section 8 and the rent arrears aspect of that and how that's going to look. And to be honest with you, the court process and how reliant that is going to be and what the timescales look like, we can't give you those answers. It is uncertain. So ultimately, what we need to be doing for you as landlords, this is your business, effectively, we need to be protecting that income. And the way that we're doing that here at David Astburys is through the Rent and Legal Protection Service. We, as Harry mentioned, partner with Good Lord, who not only work on the referencing side of things on entry, but also as an insurance provider as well. And by partnering with them, we have access to the market leading rent and legal protection insurance products, which are completely comprehensive. And ultimately, what we need to look at is is what this new process is going to be and the timeframes around it. You can't be relying on waiting now 3 months for arrears to build up, to then serve your notice, then go through the court process, receive possession of the property back before you can relet it and have income coming in again to cover your costs. Because ultimately, if rent is stopped being paid by the tenant, your outgoings do not stop. You still have to pay your mortgage, your service charge, your insurances and maintenance costs and things like that. So what we can offer here is a really quick way to turn that around. So the insurance product itself will, if you have your ducks in a row, you have your compliance, your referencing done properly in the first place, all of your paperwork tight and secure, you'll be able to then start receiving, once the claim is accepted, within 1 month, your arrears being paid. And that obviously gives you that liquidity to be able to cover your outgoings and have that peace of mind that, yes, you've got a fantastic tenant, but things change. But you've got that backup, that security, knowing that your income is protected. And look, we've done some research on our existing tenancies up till now, and the rate at which we've had to serve Section 8 notices on arrears is incredibly low. 4 in 1,500 managed tenancies have relied on that so far. But as we said, we're coming into a new landscape. It is uncertain. And for us, this is now, it's a no-brainer for landlords. We're equating it to travel insurance. You go on holiday, it's not a legal requirement, but you wouldn't go abroad without it. You're not going to take that risk. And it's the same thing here. For a small cost in the grand scheme of things, it's going to put you in a position where your income is protected for pretty much any eventuality. We now look at the compliance protection. Look, as we've heard from Susie, from Harry, compliance is key. There is no room for error going forward. And one thing that myself and my team, we speak to hundreds of landlords every day. And a big thing that's coming up is for those that might be doing bit part management themselves. They might have their properties managed by various different agents across the portfolio. But by doing it that way, you're spreading the chance of risk, different ways of working, different processes and systems. You're not 100% across that to know that everything is fully compliant and watertight. And what a lot of clients have been doing with us in the lead up to the Renters' Rights Act, to the 1st of May, is consolidating portfolios, bringing them under one roof where you have an agent that you know you can trust from all aspects, from entry for new tenancies, but ultimately existing tenancies, and making sure that compliance is watertight, as I say, and completely robust. And of course, I'm going to say that as an agent, but why can you trust us as David Astburys? We are investing so heavily in terms of personnel, systems, processes, training. While lots of agents, and you probably heard, are cutting costs, they're reducing team sizes, they're closing branches. We are going in the opposite direction, and we're taking the lead on this. We haven't waited to see what other agents have done. We are market leaders in this sense, and we're ahead of the game. And what this has been able to allow us to do, we've reduced our portfolio size for each property manager. So for us internally, we're in that kind of 80 to 90 properties per property manager. With other agencies, you could be looking at 200 to 300. And what that gives us is time and dedicated focus, not only for you as a client, you're going to have one point of contact that you can know, trust, build a relationship with, but also from a tenant side, they're going to be building a relationship with us as well. But we have the time to focus on your property and your needs and ensure that every aspect of it is fully compliant. We can't leave you with gaps, and you can trust us to do that. Now, let's look at your property, your asset, your portfolio, where it is in its life cycle. Now, I'm sure there's a lot of people who are here today who are coming in with a mindset that this is the final straw. I've had enough, all of this new legislation. It's the final nail in the coffin. I need to sell. Now, I hope from what you've seen in the build-up, from what Harry said, what Susie said, we have many different ways to navigate this. We've got lots of different strategies that we can employ to make this a viable investment vehicle for you. So you don't have to jump the gun and sell. We want to help you retain this and make this positive going forward in the new landscape. And what it comes down to is net position, effectively. And as Harry mentioned, we project rents are going to be going up. ultimately, some landlords have already sold for various different reasons. If it's taxation, mortgage rates going up, service charges increasing, and we appreciate people are being squeezed. But where those properties have exited the market and not been bought by landlords, ultimately the pool of available rental properties is shrinking. The demand is not going anywhere. In fact, it's probably increasing because it's harder to buy. So you've got this concoction of a smaller rental pool, big demand, that's naturally going to bring prices up. And it's not really out of greed, it's out of necessity to cover costs, but also what it allows you to do is not only pick the right tenants at the right price initially, but it allows you to safeguard that income with your rent protection, with consolidating it with a managed service. So you can be safe in the knowledge that across the life cycle of your property, your income is protected. But look, let's be realistic. There are going to be some of you that you are in a position where you have to sell, and that's okay. And we want to be here for you in that sense as well. A lot of the questions that have come in have been around selling and timing of when notices need to be served. Obviously, the quite onerous position of if I serve notice, Section 8 to sell, when do I get to relet if that doesn't go through? And the sales market it's been a bit doom and gloom in what you read in the media. But what we're seeing, Q1 of this year, since January, over half of the instructions that we've taken on across the board have already gone under offer or sold. It's about strategy, again, about going in at the right price, finding the right buyers. But one of the big questions is, what do we do to safeguard that sale? You can't take the risk of, if you need to serve that Section 8 notice, of doing that at the wrong time and then putting yourself in a position where you're without a tenant in the property, without income. So one of the big things that we're doing, we're readjusting our strategy, and this is tried and tested. We partner with a law society-backed firm called Gazelle, who basically set up reservation agreements for buyer and seller. And the crux of it is, this reduces the fall-through rate from a national average of 1 in 3 sales that collapse, fall out. That reduces it down to 5%. So our strategy will be, if you do need to serve that Section 8 notice, and of course, we're going to be managing the relationship with the tenant, we may be able to find a way to exit without having to rely on a Section 8 notice. But if we do have to go to that level, we can serve that with confidence on offer acceptance, because we know there's a 95% chance that that sale will go through. And if it doesn't and your buyer pulls out, you're financially compensated for that, which will cover some of the costs, and you can go again, find another buyer. But we're here to, as I say, strategize, put these plans in place, because everyone is going to be nuanced, but it's about retaining control and going into this with as much certainty as possible. And that kind of brings us on to, as I say, the timelines and how to gain possession under Section 8. And I'd love to bring Susie back in on here. We're not going to go into too much detail. You can download our guide on Section 8, the various different grounds, which Susie's already touched on. We've spoken here about ground 1A in relation to the sale as well. But one of the big questions that we get asked a lot, and especially with those landlords who are looking to sell, is when can I serve that notice? We know a new tenancy post 1st of May, Susie, you need to give a minimum of 12 months. When can someone serve that? Is it at 8 months to end at 12? Is it 12 months to end at 16? And then once they've done that, what's that kind of lockout time frame? Is it 12 months from when the notice was served or when it expires? It's a minefield. So if you can clarify that, would be fantastic.
So you're right, Adam. This has been one of the most asked questions around the Section 8. I just want to clarify that the restrictions work exactly the same for ground 1 and ground 1A. So if we have a tenancy that has already been running 12 months or more, and the landlord makes a decision to either take the property back because they want to move in, or a family member, or they want to sell, they can serve their Section 8 under either of those grounds and serve 4 months notice. Okay, so the guide here is how long has an existing tenant been in situ. And I give you the example that the tenant moved in last year, is on the 1st of May, has been living at the property, let's say 13 months, and I am the landlord. I decide that I want to sell. I will serve my Section 8 under Ground 1A on the 1st of May to expire 4 months and a few days, because I want to allow for service of notice, and that's existing tenancies. So you've got to look at timeframes, how long has the existing tenant's been in situ. But the concern is not around existing tenants, it's about the new tenancy. And Adam is right, it's 8 plus 4. So when I'm dealing with this on training sessions, I put this up on a big screen, and I have the example that the tenant moved in on the 1st of May. I count 1st of May as month 1. I will serve my notice on the first day of month 9 to expire 4 months later, and I would factor in a few days for postage, and then I will expire my notice, and that hopefully, very much dependent on the tenant's circumstances, the tenant will then vacate early June. Okay, so the restriction is something that hasn't really been very well explained, and it's about giving that tenant, new tenants, that security against the fact that the landlord could change their mind and want to sell and so on. So that's really, really important. But the other thing, and this is where you need to have a discussion with the people around you, and they could be lawyers, it could be a legal firm that you use, it could be the team at David Astburys, is if you do decide that you're going to serve a Section 8 notice, and let's say the sale falls apart, which is a possibility, and I'm not being doom and gloom, I'm talking about fact. The sale falls apart, the tenant has vacated, the market is not doing the things in the way that we had hoped, and the landlord is thinking, perhaps I should relet. The landlord is restricted from reletting 12 months from the date of expiry of that Section 8 notice. Okay, so this all hinges on, firstly, was a Section 8 notice served? Secondly, why restriction? And the restriction, the thinking behind this is, of all the grounds that are available under Section 8, Ground 1 and Ground 1A could be misused. Okay, so the premise is, before you serve the Ground 1 and Ground 1A, look at the time frames. Do you have to adhere to that 12-month window? Is the tenancy new or is it pre-existing? Talk to the team around you. Talk to David Astburys. What do I need to do? What do I need to think about? But also remember what Adam said. Adam said that the tenant can serve notice. A tenant can serve notice. Now, if a tenant serves notice on the landlord, and the landlord then puts the property up for sale, and the tenant has vacated, and the property doesn't sell, the landlord can relet, because a Section 8 was never served. So have those discussions. Think very carefully about, what does the Section 8 dictate? Where are my restrictions? What do I need to think about? And the problem with this, and this is one of the reasons that we're kind of seeing a flurry of Section 21s being served, is the press is telling landlords, my goodness, you'll never be able to sell. And that's not the case at all.
Fantastic. Thank you, Susie. That's brilliant. And look, now we're going to open it up to our live Q&A, and lots of questions have come through as we've been speaking. We obviously had a lot from you beforehand as well. We haven't got a huge amount of time, so we're going to dive into the ones that most of you have asked, and then I promise we will be following up after with an ability for you guys to have your questions answered, whether that's with a call with myself or through the documentation that we're going to be issuing to you guys as well. So look, first of all, we've had a lot of questions around pets, and I know, Susie, you've covered that in some respect as well, but we have a question here from one of our participants today. How do the new rules on pets affect landlords if damage or extra wear and tear happens because of a pet? What protection is there, and can landlords still recover these costs?
So the first point to address is that that there's still a lot of confusion about whether landlords can take a high deposit, security deposit. That was muted in the various readings. And also whether the landlord can request and insist upon insurance against pet damage. The answers to both of those questions are no. So the landlord will be reliant on the actual deposit. Now, it depends who you talk to, whether 5 or 6 weeks deposit is enough to cover damage. But the one thing that I really would stipulate here is if you do decide to give consent, and remember it sits with the landlord, you've seen the pet profile, you seem relatively happy, the tenant seems like a responsible pet owner, put together a really robust inventory. Okay, you need to demonstrate condition. Make sure that you conduct property inspections. Talk to the tenant about things that you might see during the tenancy. And then also remember that if you do give consent, and David Astbury and the team will help you with this, is that you put together a robust set of pet clauses, and they are robust. Okay, we've worked, I know it seems ridiculous because we're talking about pets, but what we're actually talking about is damage. And the tenant needs to be aware that they are signing up to a set of clauses in the event that there isn't enough money within the deposit. The landlord can then start a small claim. And I know that seems really onerous, but I'm a belts and braces person. I want to see really, really clear paperwork that looks at condition, property inspections, and then there's my evidence.
Amazing. Thank you, Susie. Next question that we've got here. So, look, again, I think something that a lot of people have been asking quite generally. I feel like the Renters' Rights Act has ruined my future plans for my investment property. Is there a workaround? Look, Harry, I think that's probably a good one for yourself to answer.
Yeah, so I do get that quite a bit. It is a workaround. It is definitely. So something that we offer and something you can look at is corporate tenancies, corporate lets. But there, again, a lot of misinformation out there on corporate lets. So some people will talk about as a guaranteed rent is a corporate let. Now, yes, in theory, you're renting it to a company. So therefore, it's a different type of contract, so non-housing act. But the difference there is they are then that agent or another entity is then renting that property out either room by room on a short-term situation. The problem with that is it brings us back to the problem of we have no control over who the tenant is. There is no tenure because naturally the tenant that they find will be going in on a short-term basis. So they will not look after the property in the same way they view it as a home, say. You want someone who's a long-term tenant who would look after it as a home. So it's an option. Yes, it's a potential workaround, but it's an incredibly risky one that I think would fall apart. Similarly in the way that Airbnb operates. Now, what I can offer and what we do actually do is the pure corporate lets. So where we actually work with, be it an embassy or something we have here is a Japanese desk. So we have Japanese speakers who work directly with companies like SMBC, MUFG, the big banks, basically, or any manufacturing company, insurance. Over in Japan, we work with their HR teams, the expat teams, in bringing over, generally it'll be higher level executive and C-suites. So they'd come over with their families, they'll be here 3 to 5 years is generally the tenure. And although the rental agreement is with SMBC, the company, there are only one set of tenants, they're not interchangeable. So it'll be that one family for the entire period in the same way an embassy let would work. But again, we have control over tenancy. Tenure, well, it's a 12-month tenancy because it's non-housing act, so we don't have to apply the same rules that are being applied to the more standard local market. But the type of tenants, they will look after the home. They're there to work, but they're going to be there, like I said, 3 to 5 years. You do a 12-month tenancy in the way we would do today, well, a year ago, I suppose, and then have that renewal situation that still exists as normal, and that's a really good way to protect yourself. But I will be honest, it's not for everyone. As you might have guessed, corporations, they are pickier with properties. It doesn't mean your property needs to be the most amazing finish, the most incredible property out there. It just needs to tick several important boxes. Those boxes being location, other minor, more niche things that I won't go too much into, but it really starts with location and the finish. Because as you can imagine, the C-suites, they have a budget of 5,000. They want an amazing house. Okay, yeah, not for everyone. We don't all have properties like that. But then their more standard level executives will be at that 2,000, 3,000 mark. And we can still rent to, and we have done. So we've worked with these companies initially through Excel, now David Astburys. We've worked with them 30 years. And we are one of the very few UK agents who are on the approved list for these corporate agencies. So we tap into a market that very few others can. But again, it's not for everyone. I know probably a lot of people will maybe not even be aware of this beforehand. And I always get asked, is my property right for that? If you do want to learn a little bit more about the corporate side of things and this Japanese desk that we do have, please do arrange time to speak to Adam. We can tell you, well, firstly, is your property right for this? Do we think we have the right searches that would fit? And maybe even for some lands, what we do is, change this, change that, and then we can give a bit of a package idea of how this process would work, what you would look at. But that's definitely a really good workaround that a lot of our landlords and managed clients do have. And it's peace of mind. That's what it is. We offer that peace of mind, that tenure. You've got someone good in there looking after the place. So I hope that properly answers.
Brilliant. Thanks, Harry. And I think just off the back of that, talking about sort of the niche sort of angles of what David Astburys can bring for our clients, obviously with the corporate side, but also one thing we haven't really touched on here is the student market. And it's a big area of concern for people. But look, I think what we need is we're going to have a follow-up session on this, a lot more guidance. We can set up specific calls for those of you who have student properties, because the Renters' Rights Act does have an impact on this group. It's just not going to be for today's session with the time that we've got. Right, I think we've got time for one more question here. And again, look, this is something a little bit off the back of the student situation as well. So we've got a lot of landlords who have already entered into multi-year tenancies, so maybe a 2-year, 3-year contract, started pre-1st of May, but will continue. If they've taken rent in advance for, say, a year from last month, are they in a position where they need to pay that rent back? And if someone's had a contract in place where it's 6 monthly, the rent, they paid their first 6 months, and then they're due to pay the next installment, for example, in July. How does that look, Susie? I mean, what do people need to be aware of in that front?
Yeah, this was a curveball when they were going through the various readings, and it caught everybody unawares. It had been actually mentioned by the previous government in the Renters Reform Bill. And basically, if you have a tenancy that began before the 1st of May, even on the 30th of April 2026, and the tenant has paid a year, 2 years in advance, on the 1st of May, that rent in advance does not need to be refunded. And if the term is based on the tenant, and I mean the clauses in terms of payment of rent in advance, is included in that tenancy, and that's what the tenancy is very clear on, then that will continue beyond the 1st of May. So effectively, where a landlord might have taken 3 years rent up front, and then can be in a position to take another 3 years up front, that will stay the same. So yeah, we were quite surprised about that, but that's, not a bad thing. Obviously, if the tenant serves notice and then vacates, then there needs to be a discussion about refunding rent, but that's as it is.
Brilliant. No, look, thank you for clarifying that, Susie. And look, we've had a lot of questions come in, some on various different topics. I think just with the time that we have today, we're not going to be able to get through everything. But what I will say is, make sure if you have put a question in, put your full name up. What we want to do is we'll come away, we'll have a chat with Susie, we'll get together and answer these questions. You can either book in a call with myself, or we'll get some answers out to you as well, because we want you to come away from this with everything you need to know. Looking ahead, we've already kind of touched on, we've spoken today about phase 1. We've had a lot of interest and questions again about phase two. We've had questions about things outside the Renters' Rights Act as well. So EPC reform and AWAB's law, decent home standards, which will form part of phase three, the PRS database. There's a huge amount to come, and I'm not going to leave you in the dark. We're going to be having follow-up webinars, and hopefully Susie will come back and join us again. It will be great to have you to give us some clarity as we move through this roadmap in the months and years ahead. So look, next steps. Hopefully we can help you formulate a plan. That's what everybody needs. And if you come away from this and you still just have a single question, let us know. We will get that answered for you. If you want to sit down and have a full portfolio review, we can do that as well. So take some time, book a session with myself. We can have that strategy call. If you're a managed client with us at the moment, we can set you up with the property manager that you have, your head of property management, and you can have that specific call just to make sure you're comfortable, confident in terms of what David Astburys are doing for you. For anybody else, I'll be your first point of contact, and then I'll be able to point you in the right direction for the teams on the front end to be able to assist you. But look, I think we need to wrap it up there. So thank you very much to everyone for joining us. To Harry, Susie, it's been amazing having you. Thank you for all your insight. And look, we look forward to speaking to you all very soon. Thank you very much.